The following presentation was recorded at the 2014 Southeast Linux Fest in Charlotte, North Carolina. It is licensed under a Creative Commons license. For more information, visit www.southeastlinuxfest.org. The Southeast Linux Fest would like to thank the following diamond sponsors in 2014 for helping make these videos possible.
Hello, I'm Deb Nicholson. We're going to talk about software patents, trolls, and then non-trolls, and I'm going to use that term fairly loosely because we've been seeing some disturbing trends over the last couple of years. So unless you have not been paying any attention, you're aware of the troll problem, right? So it's been covered pretty thoroughly, and there's like, there might be people that are like, well, trolls, you know, like people that, like modern day sociopaths that are like, I mean, that's a business model. But most of us are like, yeah, no, so in case you have been hiding under a rock, just to give you like kind of some of the scale of the problem, this is from 2011, and most of the numbers when we talk about patent suits and patents granted do this kind of exponential growth. So just imagine whatever that number was in 2011 is now a larger number in 2014. But this is $80 billion, and this is a combination of lawsuit fees, lost revenue, lost focus, products that never came to market, so lost shareholder value. There's James Besson, who's at Boston University, has like a complex algorithm that he uses to show just how disgusting and terrible the problem is. And so in 2011, he estimated it at about 80 billion per year. This is from another group, the Patent Freedom. This is the number of suits involving non-practicing entities. So just like, you know, just like all kinds of folks like to have a name that they're called that's usually different than one you might think of. They have a name. They don't like to be called trolls. I don't care if you respect that or not, but so a lot of the academic journals, in an effort to seem more professional and a little less nursery school name-cally, refer to them as non-practicing entities. Or sometimes to put a finer point on it, they will call them a patent aggression entity. So we've seen in the last couple of years that patent trolls have been increasingly targeting smaller and mid-sized projects, and not super small, but like getting at people's customers rather than the makers of technology. So instead of going after like, you know, the people that make some kind of CMS, they'll go after the people who are using it and hit them like at a smaller amount. So they're like, oh man, it's almost not even worth calling your IT vendor to see if they know about this already and just to pay it and go away. And you know, so they'll try and hit them for like $5 grand or something like that. And so this tactic is being used about 40% of the time, where they're like, you don't really know what software you're running, but you're using it, and this seems like sort of a legitimate suit, so it'll cost you more to figure out what's going on, so maybe you'll just pay us. Plus, it turns out that trolls are everywhere, like absolutely everywhere. And in just the past year, it seems like everyone finally noticed, like the NPR did another spot where they, you know, went and saw the pile of junk mail. A lot of academics wrote about the problem, not only Colleen Chen and James Besson that I mentioned, the Government Accounting Office, which you may not be aware of this, but there is like one branch of the government that all the other branches hate. They look at someone's budget and they're like, so this $10 billion a year for invisible planes that we've been giving you for like the last 8 years, like, I mean, I understand the irony that I don't see the invisible planes, but like, there don't seem to be any. So they write studies like this, and so they also kind of looked at the impact of patent aggression entities on American businesses. The FTC has plans. They've done like 350-page reports on the topic. It's not quite in their wheelhouse. They're supposed to be regulating trade, and a lot of times what they do is try and figure out if something is an unfair monopoly. But because all of the trolls are separate and they're all different industries, it doesn't qualify for their usual beat. So, but they have they've basically wrote 350-page letters to Congress saying like, if you decided that we should do something, we're totally ready, we already did the homework. Congress didn't decide that yet, unfortunately. although legislation is being talked about. This is a piece, one of the primary nonprofit proponents of this is the Electronic Frontier Foundation, and they've been very active on this issue. It's called the Innovation Act. One of the pieces is heightened pleading, and it's kind of, I'm going to try and unpack these legal terms. It means that you would have to actually describe what the patent and the claims and the product that you're suing on basis of. You couldn't just be like, it seems like you're infringing one of our patents. You would actually have to say, like, what patent, what product, what invention. It seems weird that this is not already the case, but this is not already the case. Fee shifting, this would be super helpful for larger defendants that have money to fight a patent suit, because then when they win, like when the defendant wins, like Newegg or Red Hat, they would get the money back from the troll or the patent aggression entity. So that's a good thing. Discovery abuse, I don't know if we have lawyers. I don't want to like give you guys, okay, great. So I will just go ahead and talk as if we do not have lawyers in the room. I'm also not a lawyer, just so you know. But discovery abuse, discovery is part of a lawsuit. First, there's a letter that says like, hey, we're going to sue you. And then once the case moves forward, you don't settle immediately on the first letter. They send you this thing like, well, in order for us to have the proper information for this lawsuit, you need to provide like 30,000 pages of like BS documents for us. Even if like what they only need is like 3 pages, but it's one of the ways that they make it seem more annoying. Like you get that second letter and you're like, oh my God, you're kidding. 12 years of records on like what we've been using for a Wi-Fi card in every machine, like, man, no way. So stopping discovery abuse would be like that you could complain to the judge and be like, 12 years of like total BS, like really? And they'd be like, no, okay, only 2. Many years ago, I worked as an assistant in a law office, and like, there's nothing more demoralizing than making 7 copies of 30,000 pages of documents that you know no one's going to read. So we should get rid of this just for humanitarian reasons, so like, so paralegals aren't jumping out of buildings. But it would also take a lot of the cost and the sting out of patent suits. Better transparency. So this means disclosing the real party and interest. So if you're like, I'm Steve Corporation, and then I'm going to open up another company called Tom Corporation, and then I'm going to sue under the name of Tom, but then I have a contractual deal where like 98% of the proceeds from all the lawsuits go back to Steve, then you would have to disclose that, like if you have a parent company or something like that. And this would be good for companies that care what you think of them, but for companies that are large enough, like maybe Microsoft, to not care what you think of them, like this might not be a deterrent. Limited protection for end users. So there's there's a term in Europe where they call the innocent user defense. So this means if you're a user but not a builder of the software, that you wouldn't get sued. The parent company could come in and say like, hey, how about don't sue our customers, sue us? Which is fine if you're large enough, again, to take on the lawsuit and do those things. So, you can kind of see like some of these are of general utility, some of these are of more utility for larger companies that can, throw a couple of $1 million into like a we might get it back bucket for a while. So that's a little different. So this one actually sounds great. Review the patent at the U.S. Patent and Trade Office while litigation goes on hold. So you send a suit, like, oh, I want to sue you under patent like 3,472, and then you're like, well, let's have the USPTO look at that one again. Sadly, this one not on the table anymore. Somehow, someone got to Congress and convinced them that we didn't need to go to that one. Not sure who. So what does all of this mean for the future? I think in a nutshell, it means if you have money, most of your problems around the patent system may eventually get fixed. May. Not definitely, because Congress, a little bit of a black box there. But if you don't have money, that only a few of the problems that hit you on the patent system are going to get fixed. So the patent system still has huge problems. Otherwise, I could just stop talking and be like, go home, call your congressperson, we'll be done. Not so great. So the troll business model is actually pretty lucrative. So you would think, like hearing all of these different things about how trolls operate, that most people would be like, that's despicable, right? Like if you heard someone like, they said like, oh yeah, like the other day I saw this story on the news where a little lady in an alley got her purse stolen. But, you know, and you'd be like, that's terrible. Instead, what we have is practicing entities being like, where do you find the little old ladies? So we're going to talk about that. And honestly, it doesn't matter if it's an actual company or a troll if this is you, because you still are out all the money, right? It just, that's becomes like an academic distinction, correct? So there's a couple ways this has been happening. Practicing entities have been selling their patents to subsidiaries, which is, you know, it's gross. Let me see if I have some numbers for you. So trolls don't have to care about like fair, reasonable, and non-discriminatory. So companies that are in the same industry aren't supposed to sue each other too deep down the stack. So like telephone companies, like handset companies can't be like, well, yours makes calls and mine makes calls. You know, so they're not supposed to be able to sue each other too far on down the stack. But if you're like, but yours also makes toast, and we thought of toast first. Like, okay, that's not, you know, that doesn't wipe out any competitor. So that's what the Frand doctrine is intended to hit. But what we see is, so Microsoft and Nokia sold patents to a non-practicing subsidiary. It used to be called Mosade, and now it's called Conversant. But those patents, it's like 2,000 of them. They sold them for about $100 a piece, and some large percentage of any revenue gained from the use of those patents goes back to Microsoft. So this is, you know, these are the kinds of things they're like, well, maybe we don't want to put our own name on it, and we just want to like let a subsidiary monetize that. The thing about Conversant, this particular subsidiary, is that they're incorporated in West Texas, which is where all the patent lawsuits happen in the U.S. That I found out recently that particular district as a whole has like a average juror age of like 70. So it's not and I don't mean that to be ageist, but like it's never been a tech center. So there's like a lot of folks that don't really, they're like, that computery, it sounded really complicated. I'm sure you worked very hard, you know. So that's why that district is kind of coveted, and then they now have lawyers there that are primed to take advantage of that district's strengths. So Conversant is incorporated there, but also they're opening an office in Ottawa. So they're looking to bring this troll business model to Canada, and then also to Europe. So they're opening an office in Luxembourg, which I'm told is the Delaware of Europe. It's kind of super easy to incorporate there. Anyway, so that's kind of what is happening. They're like, oh, we've got this great thing going on in the U.S. where we like, you know, we go and get special pieces of paper from the USPTO, and then we use them to make money. Like, let's see if we can export that. So that's like one way, and some of them are getting their patents from real companies. So you see that, you see anti-competitive suits where people nuisancely sue their competitor, not because they truly believe that they're infringing their patent, but because they know it will just be a pain in the butt for them. And then you see like usually larger companies sort of sending these cross-licensing requests to smaller competitors. And when I say request, like it's kind of like, you know, the first one's going to be a request, the second one's going to be a lawsuit. So, you know, it depends on where, you know, how much, do they want easy money or do they want slightly harder, bigger money? So, Another place that we've been seeing this blurred line between practicing entities and non-practicing entities is universities. They do research, they produce patents, and they also happen to almost always need money. So, you know, it's this, if you have no morals, it's a win-win. But, you know, so we see like Intellectual Ventures has relationships with approximately 300 universities worldwide. And those are only the ones that we could find mention of. For folks who don't know, Intellectual Ventures is sort of like what all the other patent trolls want to be when they grow up. So they have like something like at least 40,000 patents in the US, maybe more. It's like 300 different shell corporations, like a constant moving target, headed up by Nathan Myhrvold. So Intellectual Ventures is huge and global, and has these schools like basically making more patents for them to go back and monetize on the rest of us. So you think you're looking at schools and practicing entities and businesses, but actually they're all turning into patent trolls. You can't tell the difference anymore. They are walking among us. So that's, you know, I think that's a little different, because I think from a policy perspective, when we think about like, well, what should we do? And Congress is very focused on the troll problem, and NPR has been talking about the troll problem. And that, you know, as Americans, like, we get really upset and we're like, there are people getting money for not doing work. I'm working, I'm not into that. So like, you know, people get very upset about that, you know, unless they're children or something. But, you know, so with all the focus on the troll problem, we're kind of missing this fuzzy line where, like, you know, they're turning into our schools and our businesses, but they're still doing troll things. So what do we do about that, right? Well, let's see. Now for a tiny bit of good news. The US court system has been slightly more clueful in the last couple of months. In New York State, so this is state level, it doesn't necessarily apply to anything that happens in any other state, but there was this MPHJ, and I actually couldn't find what that stood for, technology licensing. But they were ordered to repay all of their money from their suits. They sent out a ton of letters to a ton of different companies in New York, not saying what they were suing them on, but saying like, it seems like you're infringing on one of our patents that we won't name or give you the title of, or like anything. And they're like, all right. So the court in New York State said, you actually have to make a serious good faith effort to figure out if the patent you hold actually pertains to the business that you're suing. Like, you can't just send letters to people, which seems like, well, that should have already been the case, but that's not. And then made them give all the money back, which is the real, like, okay, wow, go New York, right? So, you know, we may see some more local smacking down, but this is not the case. Like, they're not, the way the court system is that the rest of the states don't have to pay any attention to what's happening in New York. So that just means that trolls will probably avoid New York for a while. This case, which was decided earlier this month, Akamai versus Limelight. Akamai said that Limelight and its users are together creating a process that infringes on a patent that we hold, which is kind of like, wait, so over here we've provided software, and then over here the users have decided to do something with it, and because you think that whole process is something that you hold a patent on, that Limelight should pay you. This, just to put it mildly, like, it is completely the wrong direction. Instead of narrowing the scope of what we consider patentable or infringement, it would just kind of open it up. Like, you know, especially with free software, where it kind of says right in there, you can do anything you want with it, right? So a lot of, like, EFF did an amicus, like, friend of the court brief, EFF did, Red Hat, like, a ton. And the court finally said earlier this month, No, there is no such thing as contributory infringement where two parties together do a thing that is infringement. So that's good. So it doesn't really affect any of the single infringement cases that they have, there are zillions of, but it does say like, no, we're not gonna take this new type of infringement that Akamai invented, which is good. BioSig versus Nautilus, this one is, it's two companies that have a heart rate monitor on exercise equipment. And this one is just of interest because they struck down the patent because they said it wasn't clear enough. You know, but then, and also that like maybe it might have also been obvious. So it's this thing where the patent said, we put the heart rate monitor where your hand is. But the hand is the place where you read the heart rate, and then the part of the infringement that was alleged was that it was hand-sized, which for something that you used with your hand is sort of obvious. Like, why would you make it foot-sized if you're gonna put your hand on it? I don't know. But so the court basically says like, you can't sue someone for making a hand-sized hand thing because it was supposed to always be for the hand, duh. So that was too indefinite, and then also with like a side of obvious. So they, you know, just to kind of paint this picture of the court basically being like, you know, I actually did read this one and decided, no, that's silly. Sovereign versus Newegg, this is one that the Supreme Court was asked to hear. And so this one, Sovereign sued Newegg for infringing its shopping cart patents. And so Sovereign won in Texas and then lost at the federal circuit level. And then they appealed again and were like, wait. Sovereign's like, but our shopping cart patents. And the Supreme Court was like, no, we're fine with the way the federal circuit left that as like, no, it's too obvious. We're not gonna revisit that for you. This is a quote from the owner of Sovereign. She said it's a really tough time to be a patent owner. And this is, just to keep in mind, this is like a patent that was filed in 1994 and published in 1998. So like, you know, it's got maybe like another 6 months of life on it anyway, and she was hoping to squeeze out a couple more dollars, you know. So I couldn't find any violins, but for the CEO of Sovereign. But, and then the new one, so this actually marks like the second year in a row that I've showed up at the LInuxFest Fest, and like there's been some giant news on the software patent front, like within 2 days of my arrival. Last year it was that Obama guy had like a ton to say, and you know, it's like little people kind of wanted to know like how's that affect things. I'm like, yeah, the President of the United States, I should probably include that. It's like 3 pages worth of initiatives. This is another thing from the Supreme Court. The Alice versus CLS Bank, this is basically a financial thing where you have 2 parties doing business, and then you have a third party that kind of acts as a referee or intermediary to make sure that like this is being counted correctly and being paid for correctly. It is definitely not rocket science. But the reason that it got so far was that it was like surrounded by all this language that is basically, but the intermediary is on a computer. It's like, oh, whoa, high tech, like, okay, you know. So it got through the system where they're like, you know, oh, okay. And so finally the Supreme Court said, like, you can't take something that's super obvious and then just put it on a general purpose computer. Like, that's no longer okay. There is no more magical patentability for it is on a computer, which is great. It's not quite enough. Like, I don't want to crush the good news quite so quickly. This is what we call like a 101. So it's like it's not patentable subject matter to take something that people already do regularly that's like an abstract idea or like a part of nature and then just add and then you do some stuff to it on a general purpose computer. They did kind of look into it, and they're like, maybe they sort of left the door open, like maybe if it's like an extra special computer or it has like a hardware component. One of the famous cases is Diamond versus Deere, and this is kind of created some of the precedent for software and hardware working together, creating a patentable idea. It's a company that makes tires, and so they had software that controlled like extremely specialized hardware that interacts with tires. And so that's, that seems like, yeah, okay, a lot of that is the hardware, but a lot of the software cases and the precedences that we've seen from that somehow lost the hardware idea. They were like, well, I mean, this computer seems pretty special, okay, but the Supreme Court has said, like, you can't do like just general stuff on a general purpose computer, but they left the door open for if you do special stuff on a general purpose computer, or if you do general stuff on a special computer, that might still be patentable. If that, and that's kind of like in the 102 or the 103. That's another piece of the law that describes like what you can and cannot have a patent on. So it's kind of like, maybe you could think of it as like 1 down, 2 to go. In broad strokes, who knows if the Supreme Court counts their points the same way that we count their points. I kind of was wondering the other day, like, if you act in a play, like you go and you read what the reviewers had to say the next day, and I wonder if like the Supremes go and look at Patently.io or Ars Technica or TechDirt to be like, I wonder how they thought that brief went. Like, probably not. Maybe they don't have time for that, but they would learn a lot if they did. So all of that is to say that, so we've had some good news, but predators may not be stopped. So there's still some work to do and some things to think about. So what can we do? We could ignore it and wait to get eaten by the velociraptor thing. Or we could look at some community solutions and then working on some policy stuff ourselves. So we'll take those each separately. One of the community solutions, so I work at the Open Invention Network. We run a non-aggression pact for Linux, GNU, Android, and a lot of free and open source software tools. Basically, we got like 800 companies to sign this thing saying that they wouldn't sue any of the other 800 companies in this area, and that they would provide a free cross-license for each of their own patents in that area. So that, takes the amount of suing down a good notch, which is important. When we started, we had like 6 companies, so now we're at 800. So that's a lot less companies that will sue you if you sign on. We also have a defensive patent pool where we maintain patents. And there are people looking at doing these for other areas. We just happen to be the group that's doing it for the GNU Linux Android development tools area. But this is basically like figuring out strategic patents so that if you got sued from outside the community, could you countersue, and with what? Use the GPL, which has a patent clause. This means if you write something, or Apache, like, I happen to be a fan of the GPL, but using a modern patent, a modern license that mentions patents, that says like, you can use my code for any purpose, but you cannot come back and sue me for patent infringement on the code that I gave you. So, and that's not the legal definition, but that's the import. And the Apache license says this too. The DPL is coming out this year. We'll see, it's still a few months away, it's kind of in beta, but this is basically like, if you have patents, you could attach a license to them saying, like, you can use this as long as you don't sue me. It's a little bit more general. We'll see how that comes out when it's like ready for prime time. And then you could also lobby for software-specific reforms to your local patent regime. Or at least call that person that claims to represent you down in Congress, occasionally. So each patent system has its own challenges, different countries, like, I talk about this when I go outside the US, and like I use, and they're like, basically I get some version of like, why are you guys so crazy? I'm like, I don't know, but there are folks in the US like specifically working towards bringing other countries into harmonization with our patent regime. Anytime you hear the word harmonization, you know that person is not in your best interest. Like they've used a giant fancy word to be like, why don't you be more like I want you to? Which is almost never good for you. So, so we've been seeing like the US like sort of leveraging IP policy against physical trade policy. And we're apparently one of the only countries that does this. So, you know, like Australia has a ton of kangaroo meat or bauxite or whatever it is they have there to sell. And the US is like, gosh, it sure would be a shame if all that kangaroo meat went rotting or something. But we could take a lot of it off your hands if you were to harmonize with us on IP policy. So, so it's not just random when countries decide to change or you know, come closer to the US on their IP policy. There's an actual initiative underway to make that happen. So going back to the US, like specific, where we may have some power to change things, we could push for complete transparency when the suits are brought. I think that piece of the Innovation Act is great and helps up and down the board. I think going at like the, you know, legislatively the way that the patent system works at its root, and not just kind of talking about what you can sue on, what you can't sue on, but much shorter lifespans for software patents, like 2 years maybe, something like that would be a little bit closer. And I am arguing for this specific to software. Like, I think we have plenty of software patent holders to take on while we consider reform in this area without also pissing off big pharma. So I don't recommend, you know, like work on those separate. Eliminating functional claiming by requiring less fuzziness in patent applications. So fuzziness is not a legal term, but functional claiming is. Functional claiming means that you don't say like, I thought of an idea that needs a solution. And that's kind of what you get a patent for now. So you go to the USPTO and you say like, I thought of this, I found this problem, and I would like to fix it using software. And the USPTO says like, okay, we'll produce 30 pages of verbiage and some charts, and we'll do that. We'll give you that. But functional claiming says you actually have to say how you will fix the problem. That you can't just say software is how you will fix the problem.
That's how it used to be.
Well, yeah, I mean, that's, yeah, yeah, I mean, there are some other problems with the USPTO, which we'll talk about. One is that we sort of financially incentivize the patent office to offer patents. So they get a certain amount of fees for looking at an application, and then they get more fees for actually granting a patent application. So they're sort of always working on your team to help you get the patent. Because they know government jobs, there's always cutbacks, there's always budget cuts, like, you know, it doesn't take a super genius to understand that the more money that comes in, the more of us are likely to keep our jobs. So financially incentivizing the patent office is not a great plan. Some of the individual activities that we might consider, I just wanted to see how we are on time. I wanted to leave time for questions, so. Help with patent busting. We do some of that at Linux Defenders. And I'll give you guys some links for some of the places where you can look at patents that are going to be granted or have already been granted and are under review for some reason or other. Tell your lawmakers why this matters to you. I think that, so for, like, I have parents who are like, you do that tech thing, I don't really know what it is, but we're proud of you because it seems like they consistently pay you and stuff. And, you know, so it's like, you know, and occasionally, like, I got the, like, oh, I just saw this thing on NPR. Do you do that? I'm like, yeah, kind of, okay. But I think for most of the folks who didn't come to spend their weekend at a Linux Fest, software patents are this thing that, like, giant companies like Sony and Apple and Google and Microsoft fight over. And they don't, you know, it's kind of like, it's sort of hard to drum up a lot of sympathy, like, oh man, Microsoft is losing, what is it, 6 million or 10 million? I don't know, but a lot, right? Like, no one cares. Like, that doesn't really pull the heartstrings of the American people to like get something done on this terrible problem. So, you know, but the smaller companies don't get a lot of press. So I think, you know, talking to folks about like, this is not only like two ginormous companies that have several $1 billion to use to fight each other in a public way. This is affecting smaller and mid-sized companies. This is making it harder for us to get people to use free software because we can't say like, well, if anyone sues you, like, just let us know and we'll handle it, you know. So if that does not describe your company, then, you know, then you see where this is an unfair disadvantage. So, and talking to your colleagues and friends about anti-competitive behavior, it's not only trolls, although the trolls are hilarious. I mentioned Nathan Myhrvold before. This is a man who, Intellectual Ventures has so many shell corporations. He sits on the board, I think, of Disney, or one of the entertainment companies, and a piece of Intellectual Ventures actually sued this company that he sits on the board of. So a journalist noticed this and was like, huh, that's really funny. It's like Intellectual Ventures, like Nathan Myhrvold sued himself. And he wrote about it like, huh. And then that company was quietly dropped from the list of defendants. So, oh, I mean, I don't know, like Nathan Myhrvold doesn't call me up, I don't get invited to these meetings, but it seems like he did sue himself and then didn't notice until it was called out by a journalist. So, you know, so the troll stories are hilarious and ridiculous, and like, you know, everyone's ready to get the pitchforks together and go down and figure out where he lives or whatever. I'm not advocating that. I don't own a pitchfork, I'm a city gal. But, you know, letting them know that it's not always that. Sometimes it's the less, you know, the less stark black and white kind of story. It's like a larger company suing a slightly smaller competitor. I don't know if anyone has seen the readers that folks who are visually impaired use for using their computer. There's two companies that do that. The slightly larger one sued the smaller one, and because they wanted the whole market. And so what happened was that the larger one lost, but and they both still exist or whatever. But over the 3 to 4 years that this lawsuit went on, neither company produced any new features. And in case you were wondering who pays for software for people with visual impairments, it's not people with visual impairments, it's the government, the state government in most places, because they want to help those people become employable and stuff like that. So, so the cost of the software goes up. As taxpayers, we take that on. People with visual impairments didn't win because there was no improvements to their software. But almost no one knows this outside of the community of people with visual impairments. So, yeah.
And also that software is insanely expensive.
Oh, yeah, so, well, and the only check they have is that there's two companies. Like, one company has many more contracts, but that one was like, we could probably charge 3 times as much if we could just needle out this one competitor that is keeping us as close to reasonable as we already aren't, you know. So anyway, so there's the predators. It's not only, you know, it's not only the Googles and the Microsofts, and it's not only the trolls. So what we know about the general public's attention span is, so, you know, while people are talking about patent trolls and patent reform, the movement is hot. And what we know about practicing entities is that they might spin it off into a subsidiary with like a name that doesn't make any sense or sound like it actually does anything, and then incorporate in Ottawa, but they're still coming for you. So picture credits, and these are the patent busting sites that I mentioned before. So Linux Defenders, that's the one that we run at OIN. This is specific to Linux stuff. And, you know, well, Linux operating system, so GNU, Android, etc. Trolling Effects is the one run by EFF, so that's a little bit more general on, you know, all kinds of software. And then patents at Stack Exchange, where they are looking at patents there. So they're doing, sometimes people are sourcing prior art, which shows that a software patent that's being considered isn't new or wasn't new at the time it was granted. Sometimes they're looking to overturn something or find some, some evidence that it was obvious when it was granted or is obvious before it gets granted. And then if you do want to read a little bit, a lot of the academic papers tend to be pretty dense, but Colleen Chen does a really good job. She worked with the New America Foundation to put this publication out last year, and it's very readable. So if you want more, if you are having, you're sleeping too much, sleeping too well, and you want to, have more statistics to keep you up, this paper is pretty great. So I am willing to take your questions now. Thanks. Yes.
You mentioned that the GPL has a
version 3. Sorry.
Okay, GPL 3 has a stipulation about not being sued over code that you contributed. I'm assuming the BSD license does not.
No, it does not. The Apache license has a similar clause, which I'm a little less familiar with, I'll admit. But the BSD license hasn't changed. So GPL v2 doesn't mention patents because at the time that v2 was written, I think 1992, we didn't have this problem, or we didn't see it coming yet. So there's no mention of patents in GPL v2. BSD hasn't changed in a long time, and so it definitely, and it's only the 3 clauses. It doesn't mention anything about patents.
So you potentially could be sued by a company that's using the code.
Yeah, I mean, that's with some caveats, like, if, anyone can send you a letter and say they'll sue you, but so there's kind of 2 questions there, like, could someone sue you? Like, someone can always send you a letter and be like, I sue you for unicorn harboring, like, all right. And then if you can't take it to court, like, you give them money for harboring unicorns. But the second question is, if you go to court, is the court likely to be able to rule for you or for the person bringing the suit? So BSD has nothing in it that says, I wrote this and didn't intend for it to be patented. Like, the courts haven't tried this yet. So there's the second case we don't know about. Like, we don't know how that will play out. The hope by the folks who worked on the most recent version of the Apache license and the most recent version of GPL is that it would act as a deterrent to people using your code and then patenting the functionality. It's tricky because copyright law and patent law are separate. Copyright is supposed to be on the written stuff and patent is supposed to be on the functionality. So like a program has both a function and actual text within it. And so the way that those 2 pieces, 2 bodies of law interact is messy and not totally, until it goes to court, we don't know how all of the edge cases would play out. So that's why my answer is like, well, maybe, or could be, and hopefully. So, yeah. Yeah.
I heard that recently a judge on the Federal Circuit Appeals Court who had taken a rather expansive view of patent rights had resigned. Do you know what kind of effect or how much?
I don't know, and we just talked about this on the way in, and I haven't looked into that one so closely. I do think, so the situation like a year ago was where the Supreme Court says like, in another case, like their batch of cases from last year basically kind of said like, hey, you can't like, they tried to slightly narrow the scope of patentability, and the West Texas court immediately was like, took this sort of Clintonian like, well, you said is, but I think you don't mean is here, I think you mean is. And so we're gonna go ahead and basically do what we want with this like long verbiage describing like how we were like, we're actually on this side of the new line instead of on this side because we've decided to interpret your stuff this way. So I think it seemed like there was no way to be like, hey, that's not what I said. Like, so we may be starting to see some, some effort to keep the lower courts in line with the precedences laid down by the upper courts. But aside from that being like, that sounds like the right direction, I couldn't say too much more. But Yeah, and that's when I ended up looking at this one mostly before I got here, the Alice case. So, do people? Yeah.
On that Newegg one, I don't remember swear, wasn't there like counter, wasn't there? Is it still going on when they were, their counsel was actually really proud of trying to sue the patent troll back, trying to stop?
Yeah, Newegg tried to sue them back. So like, if you like when you try and go Sovereign versus Newegg, you get a bunch of Newegg versus Sovereign results. And I'm trying to let me see if I can find that. There's like.
Still in progress?
No, I think that I think it's the Newegg's the countersuit. The countersuit may actually still be in progress, but the Sovereign versus Newegg case has been denied appeal. So I don't know if Newegg's going to get money back from them or not. But yeah, it was you know, and Newegg has a couple of those countersuits in the fire, I think, actually.
They're impassioned by trying to spike.
Yeah, well, and I think that's because the CEO at Newegg, whose name I'm blanking on, but he did a TED talk on like, if you have the money, fight them, because like we all know it's a bunch of ridiculous stuff when you get like a troll suit like this. And so, yeah, I think he went looking for a lawyer who was like, oh yeah, let me at them. So I think that works out great for everyone, right? So.
Is that the same person who on TED Talks said that they had like a Kickstarter campaign for the legal defense fund?
Oh, I don't remember seeing anything about a Kickstarter. My impression was that the Newegg one was doing his own money, but that could be a different case. Newegg's fought a couple of trolls, like, and so it might not be this one.
Yeah. No, this was an individual guy.
Yeah. Oh, I'd like to see that.
Started a Kickstarter campaign for legal defense.
Yeah, I don't remember how that one came out.
From that very standpoint of,
Yeah.
standing up against these guys, they're just going to continue to walk all over.
Yeah, and it's I mean, so the kinds of money you can raise on Kickstarter like generally don't get into the same like kind of stratospheric level of the cost of lawsuits.
Get like if you're lucky, you get $1, $2, maybe $3 million, but these lawsuits cost $10, $15, $20 million.
Yeah, especially if you're gonna fight a bunch of them, you know, and it's like, yeah. So the FSF had a earmarked donation fund for a while on fighting patent suits, but you know, the amount in there was like, that'd be like a third of a lawsuit, you know. I mean, you know, I don't think they've pushed that recently because it's the kind of working on the policy end as opposed to trying to be a legal defense fund. But it's the amounts you need to raise for a lawsuit defense fund is pretty intense.
Do many of these organizations that you talk about who are working towards helping people protect themselves, do they keep like a catalog or an encyclopedia of all the cases that would be used as precedents?
So the patents at Stack Exchange, people will add information that they think is relevant to specific stuff, but that most of them tend to focus on patents that are pending and like have not yet been granted. The process, it becomes more difficult to challenge an already existing patent. Although we do know Red Hat and Novell were sued by a troll that had picked up a couple of old Xerox PARC patents. And they decided, like, it was on X windows. They were like, oh, that whole like window display object thing, you know, how they're box shaped, which is, you know, because everything on the computer is box shaped, except a Mac. But anyway, so like they got this, it was like a trio of X Windows patents, and you know, they decided to crowdsource stuff. So I'm trying to remember the precise dates. I think it was something like patents were granted in '89, and then because of who Red Hat is and who's part of their community, they were able to find the folks who had archived the Usenix list from '87 and '88. And rustle up some prior art to say like, yeah, actually when those Xerox PARC patents were granted, it wasn't new. We were all using boxes for window display objects or whatever already. So that trio of patents was overturned. but it was like part of a lawsuit. So the whole cost of a lawsuit had to be laid out in order to turn over those patents. So most of the patent busting tends to focus on new stuff because you don't have to hire a lawyer to do it. You just kind of get someone who's a little bit savvy enough to help you write a defensive publication, and then you submit that prior art to the U.S. Patent and Trade Office so that they kind of know what to look at. That's kind of the huge problem with the U.S. Patent and Trade Office, is that they don't really know where to look. Like for a more traditional field that's like a physical or mechanical stuff, you subscribe to the 3 journals that cover your area, and you just read them, and then you know what's new and what's not new. But for software, it's like, well, maybe like 12 different repositories, 1,800 worldwide conferences where people might be talking about stuff, and so it's kind of just a million grains of sand to look at. And so so the prior art work is in order to sort of put that into a place where it has the keywords that the U.S. Patent and Trade Office is looking for, so that they can figure out what is new and what's not actually new. Does that kind of answer that? Anything else? Comments? Pitchforks? I don't know. Cool. Okay, I finished a little early. Only 10 minutes. I still have this from I was at Linux Fest Northwest, but I wear many hats, so this is one of the other ones. We opened our call for papers today, so. Okay, thanks so much for coming in. Do you have another?
I have no comment. Probably this, and this may not be true, but I've been told, like it's a trivia question, it's the very first software patent that came out.
It's British.
Well, United States. Okay. So the
Oh, okay.
United States it's actually not the software patent. It was AT&T. They said UID in Unix, and they had a way they had a hardware scheme where there was actually going to be a hardware bit in limit for it. They never built that part, but and then it just somebody forgot about that part. And somehow the next thing you know, it was like okay to have software patent.
It's actually a little bit more complicated, and because we had so much stuff going on with the legislature and with the courts this year. Like I focused really a lot on that, but it was actually sort of a slow, 20 some years of general, rationalizations, towards, from machines that do things, and then the machines that have software on them and do things, and then, so it was kind of this slow descent into, I guess anything on a computer, because they seem really complicated, you could have a patent for. So I could show you some stuff offline from another presentation that kind of goes through. It was started in the 70s with we don't know if this will apply to anything, and then they applied this old precedent to new stuff, and it kind of becomes, it was just a slow kind of descent, and then I think it was in the 80s, all of a sudden, one of the cases which I'm blanking on, just kind of opened the floodgates, and so then all through the 90s you just see a zillion patents on software. So. But yeah, I could talk with you more about the history later if you want. But okay, cool. Well, thanks a lot, you guys.
Your customers rely on your website or application. If it's slow or non-responsive, it infuriates your users and costs you money. Keeping your business-critical systems humming along requires insight into what they're doing. Your system metrics tell stories that can reveal performance bottlenecks, resource limitations, and other problems. But how do you keep an eye on all of your system's performance metrics in real time and record this data for later analysis? Enter Longview, the new way to see what's really going on under the hood. The Longview dashboard lets you visualize the status of all your systems, providing you with a bird's-eye view of your entire fleet. You can sort by CPU, memory, swap, processes load, and network usage. Click a specific system to access its individual dashboard, then click and drag to zoom in on choke points and get more detail. Comprehensive network data, including inbound and outbound traffic, is available on the Network tab, and disk writes and free space on the Disks tab, while the Process Explorer displays usage statistics for individual processes. The System Info tab shows listening services, active connections, and available updates. Adding Longview to a system is easy. Just click the button, copy the one-line installation command, then run the command on your Linux system to complete the process. The agent will begin collecting data and sending it to Longview. Then the graphs start rolling. Use Longview to gain visibility into your servers, so when your website or app heats up, it stays up.